advised the Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for our cause number CV230212, McAlister et al. Versus Loeb. These proceedings are being video and audio recorded as well as live streamed, so I ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes in which to argue. Appellant is required to keep track of the time if you'd like to save any of it for rebuttal. We have read the briefs. We have discussed this case in conference. We are familiar with the facts of this case. Please bear that in mind during your presentation. And at this point, counsel, are you ready to proceed?
We are, Your Honor.
Please do so.
Thank you, Your Honor. May it please the Court, I'm Lance Entrick, and I'm here on behalf of appellants Roy McAlister, Kathleen McAlister, and McAlister Technologies. I thank the Court for the time it's taken to become so familiar with the record. I don't intend to rehearse the record to the Court, but I would like to hit a few highlights that we feel are relevant and important. I'll also reserve probably 90 seconds of my time, maybe a couple of minutes, for rebuttal. This was a granting of summary judgment. We're all familiar with the standard for summary judgment in Arizona. In Orem School v. Reeves, the Supreme Court clarified at page 309 that the standard is no reasonable juror could accept the evidence offered given the quantum of evidence required. In this case, the quantum of evidence required was obviously 51% because this is a preponderance civil case. So the trial court held that no reasonable juror could determine on this evidence that it was 51% likely not that appellants would have $100 million in lost profits, but that appellants would have $1 in lost profits. The lost profits claim was taken away from the jury entirely. So hypothetically, if a majority of 6 out of 8 jurors at the trial level determined, well, we think these 3 guys would have fallen through, but this one person we think would have made a first payment, and no, that's been taken away from the jury. The judge held at the trial level that no reasonable juror could conclude it's 51% likely that appellants have $1 in lost profits. In this case, at Index of Record 394, Exhibit 4, page 82, and this was cited to the Court of Appeals at page 12 of our opening brief. It was also cited to the trial court. Donald O'Flynn, one of the potential buyers, testified, and I quote, at line 5, question, okay, and when you say 5 up front, was that $5 million up front to Roy McAlister? Answer, to McAlister Technologies, yeah. Question, okay, and was that a number that you were still negotiating, or was that the highest you were willing to consider? Answer, no, that was fine. It was more the post-construction royalty fee that we were negotiating on. Question, and so in your mind, it would have been $5 million up front, and then any further fees would come once the business was revenue generating, correct? Answer, post-construction, yeah. And he goes on and elaborates on that. A potential buyer who had just sold a clean energy company for $250 million testified under oath that he was going to make a $5 million down payment without preconditions, without contingencies, before any factory was built, before any money was raised. And he testified at a different part of the deposition that he had the money in his accounts. It wasn't a fundraising situation. He had the money. He was going to pay it. This same individual, at the same citation, IR 394, Exhibit 4, page 202, testified that he had loaned $500,000 on the smart plug and invested $3.8 million of his own money in the smart plug. We even produced the document showing the loan on the smart plug. So this man has invested $4.3 million in the smart plug in 2014, and he's testifying under oath, unambiguously, that he intended to invest $5 million without preconditions in 2015 in the hydrogen splitter, and he had the money in his accounts. He also produced at Index of Record 231, Exhibit 4.
Is your argument going to, even assuming the expert was properly precluded from testifying, there would have been evidence sufficient to survive a summary judgment motion?
It is, Your Honor. It is our position, and we set this forth in the reply brief, that Arizona law and the law of the entire country is very clear, that you are not required to offer an expert on net present value, which is what Ron Epperson is, in order to make lost profits evidence admissible.
But you have to have something other than speculative lost profits, and you're suggesting there was evidence beyond speculation of some profits.
Absolutely. Mr. O'Flynn has just sold a $250 million clean energy company. He's testifying that he's going to pay $5 million in the immediate future without preconditions. He has the money in his account. He just paid $4.3 million. We even had Ron Epperson discount his chances of paying that $5 million at 60% a year. He produces at Index of Record 231 Exhibit 4 a draft contract that shows they were deep into negotiations. He produces at Index of Record 445 Exhibit 5 two emails that show they were discussing in detail the terms of a contract which reflects the terms set forth in the draft contract.
Counsel, let me real quick. I just want to make sure I understand. You're conceding the point that it was proper to exclude the expert from testifying regarding lost profits. Are you conceding that argument?
I am not, Your Honor.
Okay. I just wanted to make sure I understood what you were saying.
My position is it was improper to exclude Mr. Epperson. But even if Mr. Epperson were excluded, we are not required under extensive law we cited to offer an expert on net present value in order to make lost profits evidence admissible. But it is also our position that Epperson was improperly excluded.
So, counsel, I'm wondering can you draw the line for me, because you're talking about $5 million that is being invested, and those are your words, it's an investor.
Correct.
How does that play into that you have lost profits? Because just because I invest $5 million into something, some endeavor, does not mean that I'm going to make a profit off of it. So can you draw that line for me?
I can, Your Honor, and thank you for the question. It's because of the nature of Mr. McAlister's business. All his business is obtaining profits, obtaining patents and licensing them to outside parties who will then seek to make money off them and to make a profit off them. That's Roy's whole business. He's not in the business of building factories. He's not in the business of running marketing campaigns. He invents something, he patents it, he licenses it to other people. When they pay him the licensing fee, does he then take it and go build a factory with it? No, he puts it in his pocket.
And you're saying the testimony from the investors was that the payment would be made regardless whether there was an ultimately successful commercial venture?
Absolutely, Your Honor. And that is what Mr. O'Flynn testified to. So when you say 5 up front, he had just said, I'm going to pay him 5 up front. And then if the factory gets built and if this happens, blah, blah, blah. And she says, okay, and when you say 5 up front, was that $5 million up front to Roy McAlister? Answer to McAlister Technologies, yes. And later she says, and so in your mind, it would have been $5 million up front, and then any further fees would come once the business was revenue generating, correct? Answer, post-construction, yes. And this is how every patent licensing deal works. The evidence in this case shows it works that way and it was contemplated that way, but it's how it works in every case. You don't get to go say, hey, you patented this great product, awesome. I'm going to take it, sell it in the marketplace, see if it works out, and if it does, then we'll talk about me paying you a fee. That's not how it works. In this case, the evidence is clear. They were going to pay him licensing fees, and they bore the risk of the factories getting built and the products succeeding in the marketplace. And there was an argument made by the other side, well, yeah, but a couple of them said they wouldn't pay him the fee until the factory was built. My point is that the trial court went further than that and said, no reasonable juror could believe it's 51% likely that there's $1 in lost profits. You've got a guy right here who just sold a $250 million clean energy company who says, I was going to pay him $5 million without preconditions, before the factory was built, before I had sold a single product. And he had just paid $4.3 million the year before, in 2014. We even discounted that testimony through Ron Epperson at 60% a year, which means we're saying there's only a 2 in 5 chance that Roy would have received that $5 million in the next year. And the trial court says no reasonable juror could conclude that that's 51% likely. I mean, that does not reflect the case law that governs the standard for admissibility. That ruling does not reflect the case law of this court and the Supreme Court. We have 9 on-point cases that we've cited to this court and to the trial court. In one, Weiner v. Ash, all he had was a good feeling. 157 Arizona 232 at page 235. I can't identify the product, I can't identify the seller, I can't identify the buyer, but I had made money in past hot markets and I was sure I was going to make $19 million in 6 months. Well, of course, they said
Can you explain why the cloud on title, why wasn't the offer just made? Why would AGT turn it down? Why wouldn't the combination of AGT and Mr. McAlister just accept the deal? What would be the reason for not pursuing it?
He had terminated AGT's license. AGT, as I discuss in the brief, had alienated everybody. Nobody wanted to work with them, and people were beginning to realize all this talk about smart plugs. They're not even working on a hydrogen smart plug. They're working on a liquid natural gas smart plug. And so Roy, finally, when they threw him off the property, locked him out, hadn't paid him his salary money in 2 years, and hadn't done a million other things they were supposed to do, including give him proper notice of when they were not pursuing a patent. He said, all right, you're in violation of the contract. I'm canceling the contract as I'm entitled to do under the contract. They had 30 days to make it right. They did nothing. He cancels the contract. Now on June 30th, 2015, he no longer is licensing to them. He owns this stuff. He's always owned it, but they've been his exclusive licensee, and you have to sub-license through them. Now they're out of the picture. All these guys that are tired of getting messed over by AGT say, oh, finally, now we can at least deal with McAlister directly and we'll do what we got to do remedy-wise against AGT. They come to McAlister to license it, and he says, great, let's do the same territories, and we can do the hydrogen splitter that you all wanted to do, but Loesch refused to produce, and this is just going to be great. And 36 days later, they changed the name on 50 patents from McAlister Technologies to Advanced Green Technologies. These people go out to do their due diligence and they say, okay, we're going to license these patents and build factories and split hydrogen and make a fortune. Oh, by the way, we need to go check and make sure McAlister owns these patents. They go look at the patents, and every one of the patents they're interested in says, hey, it was just changed into the name of Advanced Green Technologies. So they're not going forward. They cut it all off. He ends up fighting for 3 years and paying a ton of money to get these changed back into his name as they properly should have been. And when they are changed back into his name, many of them have expired for failure to pay maintenance fees because he couldn't raise money on them because they weren't in his name. So our argument is there is not a case out there. There is not a case out there that would support this ruling. This ruling contradicts all of the case law that is relevant to this. In Great Western Bank, you didn't have a single potential buyer of houses in Flagstaff that said, I'll swear under oath I was going to buy a house. You had some expert come in and make the questionable call that you could have gotten 2006 prices in 2010. And they said, well, that creates a fact issue. Similar situation in Ruby Dawson, only then the Arizona real estate crash was 89, 90, and 91. In Short v. Riley, a restaurant closes, it's out of business. And a guy says, well, I think I could have reopened it and made a bunch of money. Court says, okay, his bookkeeper said he could have reopened it and made a bunch of money. Fact issue. In Felder, which is the only
In some of these cases, there's a track record of something, and it's a little bit different than something that's never been. If there isn't any kind of track record of commercializing something and making a profit, that seems different from those cases.
Yes and no, Your Honor. The statement was made in their response brief that he's never commercialized a product. That's not true. He has. And we will offer evidence of that at trial. That is just, there's nothing in the record to suggest that. That is a statement plucked out of the air. With regard to this particular product, the hydrogen splitter, it had not been commercialized yet successfully at that time. but it had been demonstrated to work at the lab level, and it was later commercialized and sold by Mitsubishi. And they ridicule that concept, yet somehow offer no evidence that it's not true. And it would have been very easy to prove Mitsubishi was not selling that if, in fact, Mitsubishi was not selling that. But they were. And so the product was later commercialized. It was already working at lab level. He was getting ready to say, okay, you guys bear the risk of making it commercial, and by the way, give me some of that money up front because that's the deal. They said, okay, Donald O'Flynn is one of 4 who said, sure, we'll pay you $5 million without preconditions for access to the technology, then we'll take the risk of commercializing it. And granted, the hydrogen splitter is a different product than the smart plug, but they are at least related. The smart plug doesn't work effectively without a hydrogen splitter. These same investors, 3 of the 4, had just paid $73 million for his hydrogen or his smart plug in the previous 5 years. Compare that to the Felder case, where nobody had paid him a dime to play in the major leagues.
Who had they paid?
Sorry?
Who had they paid?
They paid licensing fees to his licensee, who was Advanced Green Technologies, for his technology that he had invented. Now, I grant you, it's not exactly the same because it's a related product and he's doing it through a licensee as opposed to a hydrogen splitter, which he's selling directly. It is, I grant you, it is not exactly the same thing. But compare it to the standards set in these cases. Nobody testified they were going to promote Ken Felder to the major leagues. And they weren't. He was a terrible player. Nobody testified I was going to buy a house in Flagstaff. Nobody testified I was going to buy this commercial property from Mr. Rue. Nobody testified I was going to go and eat at this new restaurant they were going to open after it had been dark for a year. And in U.S. Fidelity, they bring in one guy, not our 4. They bring in one guy, Turner, and he says, I would have bought this whole herd for 30% more than market value. No evidence he's ever bought a herd. No evidence he has the money. 30% over market value? We're not claiming that. No paperwork. None. We offered 4 draft contracts and 2 contemporaneous emails. They had no paperwork.
When we talk about those draft contracts were created after litigation began, correct?
Incorrect.
Then clarify for me, counsel. They were not done contemporaneous with negotiations, from my understanding of the record.
They were.
So how'd they come to be?
I'm sorry, you said they were or they were not?
They were.
They were created?
Let me be very clear on that. Donald O'Flynn testified, and we cite this to the court and to the trial court, that he saw the contract he is referencing in 2015. Not after this litigation started. In 2015, he saw that contract, and they were negotiating it. Peter Barnes testified to the exact same thing. He said he saw it in 2015. Bernie Carl testified, I don't know if it was that exact contract, but I saw one very similar in 2015. And so they argued, they filed 2 different motions for sanctions, each with over 1,000 pages of exhibits, saying these were after-the-fact creations. Both motions were denied. Part of the reason they were denied is because we produced a Word template containing not the exact language, because it was a template and he was jiggering each one with the language for the particular individual. But it's the obvious template. It's 95% concurrent. The creation date on that is June 16th, 2015. So no, we do not concede that they were created after the fact. They were in fact contemporaneous. But if they want to argue the other point, great, that's a fact issue. That is not, I mean, what effectively the court did in this case, the trial court, is Donald O'Flynn ruled, hey, I was going to pay him $5 million down, no preconditions. And the court ruled as a matter of law that Donald O'Flynn was not going to make that payment.
You got about a minute. What's your best argument for why your expert should not have been precluded?
My expert should not have been precluded because every argument they offer to preclude him is either directly contradicted by Arizona law, the argument that Roy had to show a signed contract or he can't offer net present value. Arizona law says the opposite. You can't have a buyer be a potential buyer unless they show you their financial statements. Ridiculous. Arizona law says the opposite. Two of the arguments they made, hydrogen splitter has never been commercialized and the product was never identified, are not only false. They made those arguments to the trial court. The trial court rejected them. They did not appeal, and then now they're making these arguments here. And as a final matter, and then I'll sit down with about 30 seconds left, the authority they cite doesn't support any of those arguments. And as a final matter, a reason Roy McAlister was not able to do many of these things was they threw a firebomb in his business 36 days after he started it. Rancho Pescado, Rue, and Felder are all very clear that you can't blow up somebody's business early and then say, hey, they never did this and this and this because I blew it up early, therefore that's a complete defense to my tortious and potentially punitive damages worthy actions. And with that, I will go ahead and reserve the remaining 22 seconds. Thank you.
Thank you, counsel.
Your Honors, my name is Jessica Post. I'm here with Amy Abdo, and we're here on behalf of Appellee Loeb and Loeb. So I'm going to start with just the standard for where we are right now. And the trial court granted our motion to exclude. And the standard right now is whether the trial court abused its discretion in excluding Ron Epperson as an expert. Because the trial court excluded Ron Epperson as an expert, the court then granted the summary judgment motion that said that the plaintiffs don't have lost profit damages. So that's what happened. Plaintiffs, and I say plaintiff because I'm so used to it, we are litigating it. We're litigating it at the court below, but the only damages that they were seeking were lost profit damages.
So let's assume that the court properly precluded their expert. Are you saying that there is no fact issue regarding lost profits at this point in time? They don't require an expert to prove up lost profits. So let's go to that argument.
Sure. And just so you know, that's a new argument. So that argument was actually not made at the trial court and actually wasn't made in the opening brief. And then, as I understood it in the reply brief, what the argument was is that you don't need an expert to prove to discount, right, to use a discount rate to bring it to net present value. Not what Epperson did, right? What Epperson did was Epperson actually applied a discount rate that he pulled out based on, he didn't cite any authority, but he testified that that's what venture capitalists do. And he pulled that discount rate out, applied it to the $200 million that each of these potential licensees were supposedly going to invest. So he calculated $800 million. That was his number. Then he applied the discount rate of either 60% or 75%. Then he had those numbers, and then at the very end, he applied a net present value.
So let's throw Epperson's entire presentation out. Now we're left with what is in the record, the depositions of the four potential investors, McAlister's testimony as well. So this is what we're left with.
Okay.
And in that world, is there not a fact issue about whether or not there are lost profits? And if you're shaking your head, so you don't think there is,
I don't.
Tell me why.
Okay, well, first, the standard in Arizona, it's crystal clear. Lost profits for a new business, which this unquestionably is a reasonable certainty. I don't think that they can get there without an expert, which is why I think that this was a new argument that just came up literally on the stand here. But even if you look at reasonable certainty, it's got to be an individualized assessment, all right? We have no product. Mr. Entrican is
that
up.
makes complete sense with regard to the anticipated profits that would come in if the venture is ultimately successful. But if the argument is that there was testimony that there would be a payment up front, regardless of whether it's successful, why wouldn't that doesn't seem like a speculative lost profit. I understand the rest where you need a product and
A market.
But here, the product is simply the patent, and someone seems to be willing to pay for that, regardless whether it's ultimately successful. Why doesn't that at least create a lost profit as to that amount?
Well, so the thing with Mr. O'Flynn, and part of it is please make sure to look at the record with respect to the statements that are made. Mr. O'Flynn's deposition testimony was all over the place. Mr. O'Flynn testified in some places, I didn't even have an agreement. There was no agreement. Then we finish up the deposition a couple days later, he's like, oh, there was an agreement. So
But isn't that something you'd resolve as a factual matter?
it does, but if you, theoretically, yes, but even if there were agreements or not agreements, right, that, it doesn't mean that there's necessarily going to be performance under them. All of the contracts had a provision in them that said, I mean, these are draft contracts too, right? And actually, I want to step back for 1 second. Mr. Entricken talked about, there's all these emails and there was only 36 days, right? There were, and I pulled this data because this was actually part of our sanctions briefing, but there were, in a period of 2 years, over 1,000 emails. Mr. O'Flynn, he had an interest in doing something with Mr. McAlister. He did. Was there anything at all, not a single email attached as the draft contract for starters, but then there's nothing in the email that actually talks about the terms. So I just want to be clear on that. There's nothing. No emails, not with any of these individuals. 2 of them did have an interest. Nothing on these terms. So I just don't want that to get lost because we are really dealing with only declarations that were drafted in 2019 and only draft contracts. That's all Epperson relied on. I know that you want to talk about anything that's not Epperson, but I thought that Judge Foster asked a good question of Mr. Entricken, right? Which is, let's assume, we will assume that that they would be able to reach terms, right? And there was a big discussion about whether they'd be able to reach terms. But let's assume that they could reach terms. Big assumption. Then they have to pay money, right? Now, Epperson testified, and this is where there's no way to get there without Epperson. You have to take into account costs. Costs are nowhere, right? Nowhere.
But that's different. That goes to the anticipated profits from the venture. That seems different than we're going to pay you up front. That doesn't anticipate a discussion of costs.
Well, there's two sides of costs, right? So one, you've got this cost that for the potential licensees, they have to build a business, all right? The second cost, though, is to who's going to commercialize the product. All of these witnesses testified in this.
But are you saying there's no testimony that I will pay you an upfront fee of $5 million and the rest is completely dependent on the success of the venture?
O'Flynn, his testimony wavered back and forth. I'm always having to address arguments that are new, like this isn't in the briefing, but O'Flynn, in one point of his deposition, testified that there would, if he signed, right, there would be $5 million up front, and then after they build a manufacturing facility to a tune of $600 million, then...
But let's just go to the, if he signed. Are you saying there's some suggestion that he would have signed? Or that
he didn't, well, they didn't, he didn't remember there was a contract, right? So there's not a suggestion that he signed, and even in the depositions, he testified, McAlister's position has always been, okay, the minute I get these contracts, I'm going to get $20 million, right? That was one of the big things, right? Sign, money comes in. But all of the 3 witnesses, including Mr. O'Flynn, I was not going to pay money unless I paid it after the business was up and running and it's been commercialized. That was a key term. He testified unequivocally, and even plaintiffs...
I'm sorry, which witness?
O'Flynn, Carl, and Haver. All 3 of those gentlemen testified specifically that they would not pay money until after the business was up and running. That's the only contract they would sign. O'Flynn, whether he then testified that the contract that he would sign, if that was a provision in the contract, would then be an upfront payment at $5 million, he may have. He testified a couple different ways in terms of when whether there was a contract or there wasn't a contract. But he was very specific, right, that the contract, I'm not going to pay a royalty, I'm not going to pay money unless there's money that comes in from the factory. And if you think about that, that makes sense, right? If we even, and again, we give the benefit of the doubt that, these were truthful testimony, whatever. But why would you pay money, right? Why would you agree to pay a royalty of $20 million if you didn't have a commercialized product and revenue wasn't coming in? These guys under oath.
Counsel,
Yes.
I think what Mr. Entricken is saying is that was basically a licensing fee. Like, I'm going to pay you this money, and, he said $5 million, I'm going to pay you $5 million, and then that gives, Flynn, Haver, the ability to then go out and do whatever they want to do with this product. Are you saying that that was not what was being discussed?
Well, there's no product, right? I mean, what we have is we have patents in the world of hydrogen and carbon, right? So even talking about the hydrogen splitter, when he talks about Mitsubishi using it, I mean, the hydrogen splitter, as far as I understand it, is only something that's actually going to split something, right, to then create something that then is going to be sold somewhere. I don't think you're selling a hydrogen splitter. Does that make sense in terms of the product?
But isn't that on the who's ever, if someone offers, I will give you $5,000 for the
Yes.
right to use this, and if it's successful, I'll give you a lot more money. But are you saying it's just completely unreasonable that someone would agree to say, I will give you $500,000 or $50,000 for the opportunity to try to make it work, and I will pay all of the costs associated with trying to bring a product to market?
Well, so take it to AGT, right? We've heard a lot about AGT. AGT tried to create something with McAlister's technology, right? They tried to do the smart plug. They collected the money, right? We've heard about the distributorship agreements. These companies.
But is that the exact same technology we're talking about? Aren't these
Well,
different?
according to their brief, it's half of it, right? So the smart plug technology is half of the technology that we're talking. He didn't talk about it that much here, but in the brief he talks about the smart plug and he talks about the hydrogen splitter. So AGT took the smart plug, right? They tried very, very hard to actually commercialize it. They raised money to pay for their own efforts to commercialize it by entering into these distributorship agreements, and they were able to, right? The cost exceeded. They collected over $100 million. They went under. The big question, and again, this came out in Epperson's deposition and in our briefing, and part of the reason why we didn't even brief this issue, because they didn't raise it below, right? But costs are an issue. Who is going to pay to get that product across the finish line, and who is going to pay to actually build your facility?
If we put that all aside,
Here's what I need you to answer for me. Okay, I get all of that. That's the downstream stuff. What I hear today is there was an offer for licensing. I will give you $5 million, and you will give me your access to use your license to go to the downstream portion of the deal. So that deal right there, give you licensing, $5 million. That's a lost profit in his estimation. What I'm asking you is, why is that not a lost profit?
Okay, so it's not a lost profit because there's no understanding of what that, he doesn't just get revenue, right? McAlister Tech, and that's why I'm talking about costs, right? There's no question, there's no understanding, there's no facts in the evidence about who's going to pay to do this stuff, right? So I get it. No,
That aside.
right.
Okay,
But he,
for McAlister, his business is he owns these patents and sells licensings for these patents. So what we have here is a representation that McAlister from O'Flynn was going to get $5 million for the opportunity to work with him and his patents, and that's all that $5 million was to cover. Anything that happened downstream, that is part of the errors in Epperson's analysis. But I'm just talking about that very distinct transaction.
and I understand, but so Rancho Pescado, right? You have to prove net, right? You don't just get revenue. And I know that
This isn't revenue. This is just essentially a payment for a license. That doesn't depend on the success of the business.
But it isn't just revenue, because McAlister Tech, somebody has to pay to commercialize it, all right?
But that's.
But I'm talking separate about getting the buildings up, right? And that was one of the things. So like,
You're saying there was never a promise to make a payment before the buildings went up. Is that what you're saying?
that's not what I'm saying. But what I'm saying is that cost has two parts to it, right? Cost has the part that the potential licensees have to build. Then there's also cost to McAlister Tech. And during the briefing at the trial court, that's when they put in for the very first time a brief that was like, oh, McAlister Tech has no costs. And that issue came up because when we were deposing Epperson and asked, who's going to pay for commercialization, separate from the factories, right? Who's going to take that on? AGT took that on, right? AGT took that on, and it was $100 million. And they went bankrupt doing so.
But are you saying that there was not a product that was available to just take the patent and attempt to use it?
Yes, there was not a product There's no commercialized product. He's making representations that there was a commercialized product. If you look in the record,
Why isn't a patent, though, a commercialized product?
well, because you have to, you ask AGT, because a patent doesn't, ultimately, right, you have a patent, and sometimes for a product you might have 5 patents, right, or 7 patents, and they play off each other.
But can you sell a patent?
Yes, you can sell a patent.
Okay, well, isn't that what this is? I'm just selling it. I'm not doing anything else with it. I just want you to buy my patent. Will you buy it for $5,000? If you say yes, haven't I received $5,000 of profit from my patent?
Yes, but that's not, here there's no product, all right? I understand that you're saying you can just buy a patent, but there's these huge glaring holes, right? And so we have to just accept that McAlister Technologies, someone's just going to pay, and it's not commercialized. There's no evidence in the record about who's going to pay all of these expenses, and we have to just hypothetically accept and ignore the fact that there's no costs. I mean, we can't do that.
It sounds to me, counsel, as if your client's understanding of this deal was an investment, whereas Mr. Entrican's client understood this to be more of, a sale, or, just a sale of the rights to this patent. What do you have to say about that?
And why can't it be a combination of both? He's expecting that there would be an upfront payment and then royalties or additional payments.
And the truth is, that's a good question, and the problem is we're in beyond speculation land, right? There's no emails about this. There's draft contracts that 3 of these guys said, hey, I'm only going to sign it if, I'd only sign it if I was going to have to pay after revenue. Whether they understood it as an investment or a licensing, the agreement says licensing the draft license. I can't really differentiate for you, right? The distributorship...
But isn't that exactly why this would be a good question to be had at trial rather than decided on summary judgment?
No, because this is the thing. It's not, because Rancho Pescado damages for lost profits. This is lost profits of a new business. It doesn't exist, all right? They're not up here able to say, hey, I've got this product. I understand that this guy put the statement in that he testified about the $5 million that he maybe would have paid after he didn't remember the agreement, but you still have to show, right, that there is a market and that there is a product, right? When you look at Rancho Pescado, there was a guy, right? There was Frosty Fish who, got up there and was like, I'm going to buy the 11 million pounds of fish. And there was no evidence that he was going to market it. You can't just ignore the market and the fact that there's no product. It's got to be reasonably certain. And Rancho Pescado is so clear. It's got to be net, right? When they're saying, oh, I would have gotten the $5 million, well, again, that assumes that these gentlemen would have even come to terms, and as Judge McCoy recognized, again, in the Epperson motion, because this issue wasn't litigated below, but that there was huge speculation, huge logical gaps to assume that anybody was going to sign these agreements and put their names on it. And so that's essentially, it's the same, even if you remove Epperson, right, don't need Epperson, it's the same standard. These cases are applying the same standard, but this is a complex case, right? All of the cases that, Mr. Entrican cited and I talk about in our briefs as well, right? They're dealing with cattle, right? We know what cattle are. Baseball player, we know what a baseball player is in a market, right? Professional baseball, all of them. Here we're in a world that we don't even know. They can't even identify what it is that's going to be sold, and yet we have to assume that somebody's going to sign the contract and it's going to generate this when the testimony is very different and costs are nowhere. Zero place, not discussed anywhere. And other than Epperson, the one thing he does admit is that even to get the factory going would require $600 million. These individuals that, that Mr. Entrican and that they talk about being sophisticated, okay, let's assume they're sophisticated. They're not going to enter contracts like that. It's such a big analytical gap to assume that somehow the line is going to get signed.
I'm still struggling with, and
Yeah, no, that's okay.
I know it's the logical leap, and you're right, it wasn't well briefed, the issue.
But what I'm struggling with is McAlister owns patents. He's going to sell to O'Flynn some of his patents for later development for $5 million. That's what we have in O'Flynn's statement. O'Flynn and McAlister are then going to manufacture or try and get this up and running for commercialization. How do we take that one payment and find that there was no profit? Are we only looking at profit of the joint venture after the fact? Or
Yeah, you got to do both, right? I mean, no business. I understand that he's like, it's just patents. These are not commercialized patents. AGT, again, spent $100 million, right, trying to commercialize these patents. I mean, the idea that who's going to pay for it, right? Who's going to pay for the factories and who's going to pay to commercialize them are issues that you can just ignore.
But are you saying O'Flynn's testimony was if this becomes a commercialized patent, or it's different than I'm just going to pay up front $5 million?
I mean, he said he would only, like, the agreement would be executed, like, the key term was only if payments were coming in after commercialization. Now, the agreement may have had a term that he owed the $5 million up front. Again, like, we're in hypothetical land, but that was the term that he said, I'm not going to pay any revenue, I'm not going to pay any money until we've got this factory up and the revenue's coming in. I mean, that was his testimony. That's all three of those gentlemen's testimony. And Peter Burns, I mean, the thing with Peter Burns is there's actually not a single email with him, and he didn't even know when payment was going to occur.
Would you agree if the testimony is, if there were testimony where O'Flynn said, I will pay without condition $5 million, and then all future payments will be conditioned upon a successful venture, you would agree that there's at least a fact question whether he's entitled to $5 million?
No, I won't agree to that.
Even if the testimony is that clear?
Yes, I won't, because even if you had,
Counsel, your time's run, so I'm
I
going to
know.
ask you to wrap up your last.
Okay, I would say no, because even still, we have this whole cost issue that is nowhere in the record. Epperson had nothing, and McAlister has nothing on it. They just want to assume I get $5 million and I get to put it in my pocket. Doesn't matter that I don't have a product. Doesn't matter that I can't identify the market. Doesn't matter that I don't know how much it's going to cost. Doesn't matter how much these guys don't know how much it's going to cost. That's not reasonably certain under Rancho Santa Fe. And I also want to reiterate, I mean, it would have been easier for me. I know, I'm sorry. It would have been a lot easier, though, had some of these arguments, they get raised for the first time here, right? Never before. That's how this pattern of this case goes. And so, you know, this was never, we have multiple levels of waiver for each argument that gets raised.
Thank you. Can you add 20 seconds to his time, please? And you're welcome to get up. We have to do it one at a time. It takes a bit.
Okay.
Thank you.
Please proceed, counsel.
Thank you, Your Honor. Just very quickly, 80 Arizona 286 at page 294 and 3 Arizona App 562 at page 566 are clear that expert testimony on net present value is not required for admissibility of future lost profits in Arizona. That was also the case in the Felder case, the Great Western case, the Short case, and the U.S. Fidelity case, all of which admitted lost profits evidence without a net present value expert testimony. With regard to the assertion that there's nothing in the emails discussing the contract terms, I would ask the court to look at Index of Record 445 at Exhibit 5. With regard to the argument that Mr. O'Flynn waffled, he did not. He was very clear. But even if he had waffled, the appropriate ruling is not to say, I picked this one version of it that favors defendants and rule as a matter of law. And with
All right, counsel.
I thank the panel, and unless the panel has any questions, I'll sit down.
I thank you both for your arguments. We have a lot to think about and discuss. We will take this matter under advisement and issue a written ruling in due course. We are at recess.